Bail hearing BA, item number 1.
Sorry, Mr. Raman, I think Mr. Shekhar, Mr. Murray, you're also here. I was in a division bench.
Yes, we saw on the live.
Oh, sorry,
That's okay.
it wasn't in my hands. Yes, Ms.
We just
Kumari.
want our bail, Your Worship. We have no problem in waiting, Your Worship. We just want our bail.
No, that is why even this court is also conscious. You see,
Yes,
these matters. The problem is I'm in division bench, so
Yes, Your Worship.
difficult.
Not an issue, Your Worship.
Yes.
Your Worship, as per Your Lordship's last direction,
No, it's all right.
we have the order of the CBI court, Your Lordship.
So charges still not framed.
No, Your Lordship. And it has been fixed on 11th of September.
11 September.
Yes, Your Lordship.
Ms. Kumari, it appears that against this for item number 1, no? Yours item 1.
Yes, Your Lordship.
The only allegation against right now which appears is that the petitioner had circulated a particular video clip of that naked parading, right? This is what has come against this particular applicant.
Victim
A
has
petitioner.
Victim has identified.
Yes, I'm not
the-
saying that has not
164
identified.
statement
Identified his presence in the mob at that place. Correct.
It's the question of.
See, now that
evidence at the time of
now you see,
cross-examination.
this is not a punishment court,
Yes.
right? There can be no doubt that the crime is very heinous. Absolutely, there cannot be of any doubt. In fact, the last order of this court is also very clear to that effect, right? But it appears that since then, nothing has progressed.
But
Nothing
that
has
is-
progressed.
But that is
The-
not due
the
to the fault of
petitioner-
prosecution.
See, whosoever's fault it could be, but the fact remains that the petitioner has been languishing in jail for more than 2 years.
Yes, Your Worship.
Yes, Your Lordship.
Correct? And since the last date of rejecting the bail, nothing has also happened in the trial court. Charge has not yet been framed. Even today, on the last date, which was day before yesterday,
Yes,
right?
on 28th of August.
Same, it is still at the same stage. You see, I'm just trying to consider because otherwise this is not a rehearing. I'm not
That-
rehearing
To
the-
that effect, yes.
I am not
Have the
rehearing,
judgment
correct. I am not
and that-
rehearing.
that
You
is
see,
the-
let's not get into that. I'm not rehearing the bail application. The question is now Article 21 as well, because speedy trial.
That is true, but
Right.
it is also the fundamental right
No,
of the
no,
victim
if that
also.
that is
That balance has to be seen.
fundamental right of the victim. What fundamental right of the victim?
Means
Here,
the balance
the
has to be seen.
that is you see, how can the court ignore the fact that this petitioner has been languishing for more than 2 years and charge sheet till date has not been framed? How do we ignore that? How do we ignore that? Please tell me that, because what is the order of rejection of this court?
Your Worship, the order of rejection, Your Worship, it was on 9th of May,
9
May 2025.
May 25. We are today 1st September 25. It's exactly the same stage, framing of charge, yes or no?
Yes, Your Lordship.
That is,
Yes,
nothing has happened. How many dates have passed since before the trial court? Since May.
I think it must have been around 5-6 days. Your Worship.
That is because the.
15 days. 15 days it has been listed, Your Lordship.
So, but what is happening in this 15 days? Why is the charge? Why till now no progress have been made?
Sir, appropriate direction may be given to complete.
Your Worship, in most of the hearing, Your
Miss
Worship, the CBI
Kumari,
the
I am
custom of
only
CBI doesn't-
considering the bail player here. Please be conscious of that. I cannot give such a directions.
Milord,
Yes.
if your lordship kindly go to the second page of the order.
The order which you've given
Yes,
today.
the
Yes,
same,
sir,
the
it's
same
that.
order, the second page. It appears that Larned PP CBI has not entered appearance which hinders further progress.
Who's not appeared entrance?
It appears that Larned PP CBI.
Yes, it appears that learned PPCBI has not entered appearance which hinders further progress in the case.
Let this fact be intimated to HOP.
Miss Kumari, what is this?
This may be some of the reason. one
You see,
may
no,
also-
no, this court is not concerned about that.
That is
You see,
not
playing the
regular
victim card
phenomenon.
always will not work. We have to balance everything, correct? Now here is the fact that this particular petitioner has been languishing for more than 2 years. last time this court rejected the bail prayer, that was in the month of May. That nothing has progressed since then. We are in September. The order of the trial court indicates that the CBI lawyers are not appearing, which is hindering the
Then
progress of the
it's
case.
Single day probably.
Whatever be it, but it is a judicial order and it has been placed before this court. This court cannot ignore such fact. Yes, Mr. Rahman, where are those cases on
Print out.
delay, prolonged delay
Yes,
defeats?
sir.
But in the.
I have already
aspect
submitted
what
my
I
written
have-
argument, Your Lordship. I have
Yes.
annexed all the judgments, Your Lordship.
No, which are the judgment on delay? I am on delay.
one
I have
latest
read your
judgment of
judgments,
Supreme Court, Your
but
Lordship. I have
what
one
about
latest
the
judgment
delay?
Of the similar.
I'll come to you. Please take your seat.
Yes, sir. Your Lordship, I have this judgment, Your Lordship, it has been passed by the Delhi High Court. Although it's a
Where are
confirm-
Supreme Court judgments
Yes,
on delay?
yes, sir. Delay on Supreme Court judgment is also dear, Your Lordship. Your Lordship, it is in my written argument, which I submitted on the last occasion, Your Lordship, AIR 1978 SC 527.
Page
Your Lordship, I have flagged it, Your Lordship. I have
78 Supreme Court.
527, Your Lordship.
Yes.
Your Lordship, there's para number para number 8, Your Lordship. The next page, or page 529.
Yes.
Your Lordship, if we read, Your Lordship, I'm allowed to read, Your Lordship. The court is cryptic on this topic. The court prefers to be taxing, be the order custodial or not. And yet the issue is one of the liberty, justice, public safety, and burden on the public treasury, all of which insist that a developed jurisprudence of bail is integral to a socially sensitized judicial process. As chamber judge in this summit court, I had to deal with this unchannelized case flow ad hoc response to the docket being the flickering candlelight. So it is desirable that the subject is disposed of on basic principle, not improvised, brevity drab as discretion. Personal liberty deprived when bail is refused is too precious a value of our constitutional system recognized under Article 21 that the crucial power to negate it is a great trust exercisable, not casually but judicially, with lively concern for the cost to the individual and the community. To glamorize impersonating order as discretionary may on occasions make a litigative gamble decisive of a fundamental right. After all, personal liberty of an accused or convict is fundamental, suffering lawful eclipse only in terms of procedure established by law. The last 4 words of Article 21 are the life of that human right.
Yes, but there are much better decisions of the apex court on this
Yeah.
point. The latest decisions, where are those, Mr. Rahman? You started from 78.
Yes,
You see, you don't have much time. 30 out of 30 minutes already, some minutes have gone.
yes, Your Lordship.
Please show me those points. Where are those decisions? The latest decision. Yes, Ms. Kumari, which latest decision you were referring to?
Yes. The Supreme Court has taken very exceptionally because the High Court has given the similar to our case, gang rape and this type of.
You see, don't go on facts. Please don't remind this court about that. Gang rape doesn't mean that in all cases of gang rape, this court is, then what, where is the concept of giving or not giving bail? It's a discretionary power of the court. It will depend on the facts of each case. Here is a case where the CBI counsel is not appearing before the CBI court. This is what your judicial order is showing. The petitioner is languishing in jail for the last 2 years. Please be mindful of what you submit before this court. Para 14. Ordinarily in serious offences like rape, murder, dacoity, etc., once the trial commences and the prosecution starts examining the witnesses, the court, be at the trial court or the high court, should be loath in entering into the bail application of the accused. Even in para 16, here in this case, the trial commenced. But where has the trial commenced in your case? The charge has not been
This
framed.
has not been framed.
I am on that, Mrs. Kumari. Ms. Kumari, please be. That's why I've said, had some progress was there, it was another thing. From May to September, nothing, and then the order shows that CBI lawyer is also not cooperating.
Your
What
Sir,
is this?
The thing
I
is
had,
that-
I had-
Para 15, para 16, para 17, everything is remembered.
Your Sir,
Here is a case where even in para 16, the apex court have said, we are of the view that the aforesaid is not a correct practice that the court below should adopt. Once the trial commences, it should be allowed to reach to its final conclusion, which may either result in the conviction of the accused or acquittal of the accused. This was in the observation because generally what happens, the moment the trial commences, there is a tendency of granting bail after the victim statement is deposed in the court. You
Yes.
see, that is a trend that certain time is being followed. So on that, the apex court have said. But now these are ultimately the discretionary power of the court. On delay, where are the decisions, Mr. Rahman? Huh?
I have annexed one judgment of the, Your Sir, although it's a concurrent jurisdiction, it's of the Delhi High Court.
Where?
I have flagged it, Your Sir, the Tahir Hassan versus State.
Yes.
Your Worship, may I kindly to come to the para number 10.5. It is at internet page number 18. Ten point five, Your Lordship. The internet page number is at the bottom, Your Lordship, page number 18.
Internal page 18. There is no
Yes.
pages.
In the bottom, Your Lordship, there is a page number, Your Lordship.
Okay. Ajay, this flag is there.
Yes, Your Lordship.
Yes.
Your Lordship, the para number is para number 10.5.
Yes.
Uh,
Read.
As regards FIR number 5 filed on 17 July 2020, the petitioner was arrested on 21st April 2020 and has already undergone more than 3 years of custody, while all the other 9 co-accused have been granted bail and the petitioner was not named in the FIR and the complainant later improve upon his statements. As regards the offense punishable under
But
section...
you see, this is on a different. Here,
Yes, Your Lordship, but
the
Your Lordship, Your Lordship,
you are on a life
further
imprisonment. They're bailable in nature. In any event, the maximum punishment prescribed is either 2 or 3 years.
Yes,
These are cases of no help to you.
Your Lordship, but
Petitioner has already undergone more than this
despite the
period.
charge sheet,
There are
further-
44 witnesses and the trial will take more time to. You
further,
see,
despite the charge sheet being filed in July 2020, the
That is
charges
all
have
right.
not been framed. Your
why both of you are not just giving me the judgment which is actually required?
Your Lordship,
This is a matter
Learned
of
brother is
delay.
bringing the judge-
Where are those decisions? Even in cases where regards of Section 37 NDPS and the other acts are concerned, even in the context of those cases, the PMLA cases, where are those cases?
Until
When the
this-
apex court have
until
clearly
the
said,
Jalaluddin case, my friend is bringing.
Yeah.
Until
Yes.
cases, in
those are the
Jalaluddin-
cases.
Jalaluddin is on UPA and until he's on PMLA.
You don't have the cases which are in support and you are showing me this 2 years imprisonment, maximum term 2 to 3 years. And here is a case where life and such heinous and grave, Mr. Rahman,
Yes, Your Lordship, my learned brother is bringing the
you
judgment,
expect
sir.
me to go by those kind of, huh?
Your Lordship,
Your objection, where is the objection, Ms. Kumari?
I- Objects, affidavit in opposition is there. Your Lordship.
Where, can you tell me the page?
161.
161.
161.
161.
Yes, sir. This is in respect of N. Kiran Maiti.
Yeah, I think if I recollect, one, you
Mr.
said that there are incriminating materials, which you say that the victim has identified,
That is
and
page 166 is there.
page 166.
66. Para K.
And the other one, I think you are
During
saying
the
is
course of investigation.
correct.
Statement of victim 1, victim 2.
para.
Para K. K for Kamble.
Okay,
166.
yes. Now,
With regard to the photo test identification. panel.
so basically there are incriminating materials. Now, the other thing is that about the witnesses being
I think para M is also there.
now
That is-
see that it appears that these witnesses are already outside. They have left, and suppose we give a bail and we give a condition that they will not be going to these places where the witnesses are, where the victim stays.
Your Worship, we cannot go, Your Worship. Even if we want, we cannot go.
No, we can
Because
put that as a condition.
Yes, Your Worship, any condition we
If
accept.
I'm saying, I have not decided my mind, Miss Kumari, but going
Yeah.
by the fact that they've been languishing in jail for so many last years and seeing what has happened on the last date in the trial court, now considering.
But all said and done.
Anyway,
there is
we
no
will come.
watertight compartment.
We will definitely hear that. But what I mentioned is that these people cannot come back to their houses. They're scared,
Yes,
but they
this
will
is
not
what-
go there.
But there is no watertight compartment.
Milord,
as such.
What watertight compartment? Yeah, why are you not providing them the protection to them? You can protect. It is your duty. You will not produce, and these people will be languishing in jail. Yes, Mr. Shekhar, you got those judgments.
Get the printouts.
Why?
The lady was not there in the library. I had
Well-
the copies of
And
if
that
I have
too,
residence.
Now, I have given another judgment of the Supreme Court with regard to the review of judgment, and that is fixed about the 362. That is also there. Your Lordship. I have given, just now I have given along with my that judgment. AIR 2001.
Anyway, since you all are not ready, we will have it tomorrow, next Monday.
My lord, if your lordship is pleased, we'll get a printout tomorrow and we can have it tomorrow because now so far the conditions are.
You'll have to wait till what time, you don't know tomorrow again.
We'll wait, we'll wait.
We've seen that heard Mr. J. Rahman, learned counsel appearing for the petitioner. Also heard MS M. Kumari, learned CBI retainer. Mr. Mr. Rahman, as per the last court's order dated dated so and so Sailuva, produced a copy of the order passed by the learned trial court in special case number 7 of 2025 in FIR number so and so on 28/8/2025, which indicates that on the last occasion also, due to the non-appearance of the CBI lawyer, no progress could be made in the case. Considering the snail pace of the thereafter, in order However, Mr. Rahman did not have the authorities on prolonged trial in support of his arguments that the delay in the trial has clearly infringed the precious fundamental right guaranteed to the petitioner under the Constitution of India. Relist tomorrow on such and such date. Please get me those decisions
Yes, Lord.
on prolonged trial.
Tomorrow I'm leaving, so my brother will be.
Whoever, Mr.
Yes.
Singh.
I'll keep all the.
I'll appear through VC tomorrow.
1 and 2.
1 and 2. Mr. Shekhar, any more case laws you want to rely, you give it tomorrow.
Yes, sir.
Instead of that downloaded, we'll hand over the certified copy.
Yes, sir.
This is certified copy.
So I'll return back this.
This is certified, this is downloaded.
If Ms. Kumari, can I have a scanned copy of the trial court records? Can we get that by tomorrow?
By tomorrow, it is not possible.
Next Monday?
My lord, so far the.
Next Monday?
Monday, I will try to get it. by next Monday.
I got it, Lakha. That considering the tenor submission to present, I did query him, huh? Considering that the considering that after this court rejected the first bail application filed by the petitioner on Mr. Raman date on
9/5/2025.
9/5
2025.
2025, comma, there hasn't been much progress in the trial, inasmuch as it appears that charges has also not been framed till date. However, before further proceeding into the matter and hearing the counsels further, this court directs the registry to call for the scanned copy of the trial court records. It will be, isn't it? Trial court records in, please give the number, so and so. Can you also get it?
I will try my, best. I will ask IU to.
Please give the,
Special case number 7/25.
so and so.
No, orders is available on the website.
Parties are also at liberty.
All the
Parties are also at liberty to produce the copies of the order sheet of the trial court.
order sheet can be produced tomorrow itself because it's all available on the website.
We can
But-
produce everything tomorrow.
I want a scanned copy. It will be better. We'll have it on Monday. You should have been well prepared. Monday. Have all the decisions.
Yes, sir.
Monday.
Tomorrow,
Monday.
Monday is okay.
then no, this won't come tomorrow. then.
No, I'm giving you time so that I wanted the scanned copy. That would be
Yes.
more authenticated.
Yes.
I want, because certified copy to you will not be able to give it by tomorrow. Certified copies. Are you sure?
We can get it by two. Because it's only Xerox and certified copy, you can get it tomorrow. Because that will be the latter part and we'll come with all the preparation with all the decisions.
No. What later?
No, the latter part means like
After
Oh,
that.
after lunch.
Don't
take a-
predict, Mr. Singh.
No, you're not usually.
Every day is a new day.
You're not
Yes.
sitting in a division bench.
That's right. That's why I'm saying don't predict. Every day is a new day.
Or
I-
it can be fixed day after tomorrow. We'll argue
They are only thing I shall not be. I'm going to be on leave from 4th, so that is why I was not sure of Wednesday.
Yes, your lordship, please.
Next.
Monday. In the meantime, see, because you can't rely it on the registry because they may not have the scanned copies available even if we have directed it for Monday. So you
We'll
get
get
hold of
We'll get the
whatever scanned copies. Okay, I've said. Okay, order sheet को do. Huh? Scan copy of the order sheet of the trial court. That should be sufficient in
Yes.
so and so. Please provide him the
special case
numbers.
number- Special case number 7/25.
7 of 2025 pending in the court of.
Special Judge CBI Chanmari.
Aisa? All right, Monday, huh? Are we at Assam?
For hearing, item number.
See, there are, I remembered one is Ravi Prakash, but that is only a one-line judgment, but that is only on, I think, that says in addition NDPS.
Yes.
But it is clearly said that when there is, and that is 2 years something, I think, in that case. So Ravi Prakash is one, and there are more. There are more. You can find something on such
Yes,
kind,
absolutely
because
fine.
the ones which I have in my mind are all either PMLA or NDPS.
Yes.
That apart, also you may have something in such kind of crimes because
Yes, sir. All the judgment I'll scan and send to my
yes,
brother.
at least 2-3 is also good enough. Otherwise, you'll overburden the court. But the main ones.
Yeah, I'll scan and send it to my brother. He can produce.
Okay.
Alright, Masud.
Item number 3.
See, I think this matter, the hearing already was over, isn't it? So, in fact, I have also prepared a draft, but some clarification was required. Do you have the copy of the rules? the recruitment rules and all, the UGC rules? Are you having it?
No, they not. I don't have many.
Then let me indicate what is the the confusion, then you can accordingly, have it. So this first regulation is this 1991 regulation, correct?
Yes, ma'am.
That is the regulation
Yes,
which prescribes qualification, correct? Then it comes that schedule 1 which has lecturer, right? Then comes that clause 4.40 and 4.41. Now this is what? This is the UGC 1998 notification or regulation? I have a confusion of that. What is this 4.40 lecturer where that SLET requirement is given? It says, besides fulfilling the above qualifications, candidates should have cleared the eligibility test NET for lecturers conducted by the UGC. For class 4.40 and 4.41 of the UGC 1998 notification, I found in one of your written argument it was mentioned, but is this a notification or this is a
98 resolution.
it should be a regulation. So where is that? See, this was handed over by whom? By the respondent. You had handed. Now, what is this? It says UGC notification. Where have you got this from? Lydia? Just have a look at this. Under what has this been framed? Is this a part of the regulation? What is this? Because this has a lot of, meaning in the whole case. Bhargav, to meet you. Bhargav Thaka. What notification? Because I have seen it referred in some other cases also, but what is it? Is it an, if it's a notification, is it under what provision has it been framed?
I think the entire copy is not there, madam.
That's why, because you see, thereafter comes your 2010, right? Are you understanding why I'm asking you this, Mr. Counsel? Because that requirement of clearing SLET
Yes, ma'am.
was initially not there in the 91 regulation, right? 91 regulation nowhere said SLET.
Yes, madam.
Even in that schedule where that lecturer is, it doesn't say. It only says candidates besides fulfilling the above qualification should have cleared the eligibility test for lecturers conducted by UGC,
Yes.
CSIR or similar tests with. So this will the similar test means what? NET, NET.
Conducted by UGC, CSIR or similar test accredited by. Yes, madam. Next.
That would include NET. SLET.
State. State for state.
But what about NET? Does it include NET? Because this is your UGC regulation.
Well, I'll clarify.
Just clarify this position to me, okay?
Yes, madam.
Whether NET would also be covered under that lecture schedule 1 of the 1991 regulation,
Yes, madam.
And after that, I was trying to find out the sequence of these notifications. I found 440, this one notification.
Yes.
Here you talk about NET for the first time.
Yes.
Have you got that clause? I think
It's
I've,
yes, madam.
yes. Then after this comes the 2010 regulation. Now here the argument was that this 2010 came later, where the PhD degree requirement was set and it says exempted. It was simple. So just these two things, please clarify.
Yes.
When can we have it? Monday?
Yes, ma'am.
Monday, Tuesday too. Only for that, huh? Because otherwise, more or less, I have already dictated the
Draft.
skeleton. I'm not being able to conclude because I'm not getting a clarification there.
I'll clarify. madam.
So that part.
Yes, ma'am.
Heard so and so Korean. Though today the matter was posted to make an endeavor to dictate the judgment in the open court. However, since currently this bench is sitting in the division bench, and therefore, due to paucity of time, the attempt could not be made. In the meantime, the respondent counsel shall further clarify as whether clarify as regards the clause 4 as regards the UGC 1998 notification which they are relying upon, as under what provision the same has been made. Okay, to Monday, list for further hearing on Monday.